as you know, I will talk about the recent case law of the Court of Justice in asylum and return. I had to choose among many cases brought before the Court of Justice in the areas that you can see, so it concerns the interpretation and the application of many directives. I had to choose among a lot of cases, but the idea that I would like to underline in my presentation is to try to let you understand in which way the court reasons each time that it delivers a judgment, and to point out, to underline the important role played not only by the Court of Justice, but the more important role, in my opinion, that both national authorities and national courts play at the national level. So I will start immediately with the first case. Most of the cases we will talk about come from references for preliminary ruling, so from national courts. Why these cases are important? Because the judgment delivered by the Court of Justice must be applied, as you know, in all member states. And all national authorities have to take these judgments into account where they are facing similar situations in similar disputes. So the first case I would like to talk about concerns the interpretation of the Return Directive and Directive number 33 of 2013. It concerns the possibility and maybe the obligation of national court to proceed to ex officio review of the lawfulness of detention measure adopted against third country national. In this case, let's have a close look to the facts. We have nationals of Algeria, Morocco, and Sierra Leone who challenge before the Netherlands courts detention measures that has been taken at the national level. In the first case, the district court finds that the state secretary didn't act with due diligence, and so there was an action brought before the Council of State. In the second case, these are joint cases decided by the Grand Chamber of the Court of Justice, Moroccan national brings an action, an appeal against the continuation of detention measures, but the doubts that these national jurisdictions have are the same. Why? Because according to the national law, actions brought against the adoption of detention measures fall within the scope of national administrative procedural law, which does not allow the Netherlands court to examine of their own motion the lawfulness of the detention measures, so unless the person concerned has not claimed, has not brought any action on this point before the national court. So the questions brought before the Court of Justice concerns whether the EU law, and in particular Article 15, paragraphs 2 and 3 of the Return Directive, and Article 9, paragraphs 3 and 5 of the other directive, read in conjunction this time with two provisions of the Charter of Fundamental Rights, namely Article 6, so right to liberty, and Article 47, effective judicial protection. They require courts to review of their own motion any failure to comply with the condition related to the lawfulness of detention measures which has not been invoked by the person concerned. And it's interesting to have a look to the reasoning followed by the Court of Justice that starts at paragraph 72 of the judgment of the court. The court states in the first place that any detention of a third country national in the context of both directives constitutes a serious interference with the right to liberty under Article 6 of the Charter. And the court recalls that the purpose of a detention measure in the context of this directive is not a punishment, but is just to allow the administration to check the identity of the person concerned and then to see if he needs or not a protection in the member state. So the power of the competent national authorities to detain third country nationals is strictly circumscribed on the one hand, and on the other hand, where it is apparent that the conditions governing the lawfulness of the detention have not been or are no longer satisfied, the person concerned must be immediately released. And this is the case when it is found that the administration didn't act with due diligence or where the measure is no longer proportionate. According to Article 47 of the Charter, the Court states that both provisions of the directives allow member state, oblige member state to provide where detention has been ordered by an administrative authority for a speedy judicial review. And this review must be done either ex officio or at the request of the person concerned. So there are two different options. But there is an obligation to require periodic review or supervision, and this supervision must be done also at the own motion of the judicial authority involved. So it means that beside the fact that national law doesn't allow the national court to proceed to this ex officio review, EU law, namely the provisions of the directives, oblige this authority to do so. On my opinion, this is a typical example of primacy of EU law on national law and of the importance of cooperation that is needed between, on the one hand, the Court of Justice, and on the other hand, national authorities and judicial national courts. This case is particularly interesting, and it concerns the interpretation of the Family Reunification Directive, namely the concept of an accompanied minor. In a very sensitive case, we are facing a married refugee minor, so there is a child marriage in this case, and on my opinion, the decision of the court was quite important, but it maybe can be discussed in the second part after my presentation, because there are a few points that I would like to point out with you. What is the situation? A 15-year-old girl married a guy in Lebanon who had a valid permit in Belgium. She joins him in Belgium and she applies for family reunification. National authorities, they don't allow the reunification because they say, wait a second, we are facing a child marriage, we cannot allow that. So they assign her a guardian, and after a while she could apply to obtain refugee status in Belgium. Immediately after that, so let's have a close look to the timing in this case. Her mother applies in Belgium for family reunification with their daughter, saying that I have two small children, I want to join my daughter who is legally in Belgium and she has refugee status. And in this case, the administration says, no, we are sorry, we have a valid certificate of marriage, your daughter is married, we cannot grant this reunification. So it's a bit strange, the attitude of the national authorities, which on one side they say, no, there is no marriage, there is a marriage, we should stop it, and on the other hand, there is a marriage, we cannot allow the family reunification. So the case brought before the Court of Justice is whether Article 10, paragraph 3, which states an obligation, be careful, for member states to family reunifications of the parents of a minor refugee, needs that the person who is sponsor of the family reunification is unmarried or not. And when I started reading this judgment of the court, I was a bit surprised because it was too legal. There was nothing empathic in the reasoning of the court. The court states that Article 10, paragraph 3 of the Family Reunification Directive doesn't require any marriage. So the fact that the person is married or not is not a condition according to Article 10, paragraph 3 of the directive. But then the court states that there is, sorry, I will try to slow down, there is an important recital in the directive, recital 8, which says that there is a special protection that must be allowed to refugee minors. And according to recital 2 of the directive, the directive respects the fundamental rights. But now, which are the fundamental rights that we are applying in this case? Is it the right to family reunification or the protection of the child's best interests according to Article 24, paragraph 2 of the Charter? And there is also another important article, paragraph 3 of the same provision, that states that the refugee minor has the right to spend time with both his parents. So this case was a bit tricky. Finally, I was glad to see that at point paragraph 44 and 45 of the judgment of the court makes it clear. And it says that in the light of the context of the directive, an interpretation of Article 10, paragraph 3, which restricts the benefit of the right to family reunification only to unmarried, unaccompanied refugee minors, would run counter the objective of special protection of minor refugees. And the court says, at paragraph 45, in particular, the fact to require that a minor is married may point specifically in the case of minor girls to exposure to the serious form of violence that is child marriage and forced marriage. So finally, the court takes a position in this case. But if we just read at the conclusion is that Article 10, paragraph 3 does not require the sponsor to be unmarried. So this judgment, in my opinion, is very important, and the impact of this judgment can be very important. But we have to have a close look to the facts of this case. The court said that marriage is not a condition. But the problem is that if the court would have said, this is just my opinion, the contrary in this case, this little girl who is just 15 years old, she wouldn't have received any protection in this case. Why? Because she couldn't get, of course, any family reunification with their supposed husband, but at the same time, her mother was not allowed to spend time with her. So in my opinion, it shows how important is the examination of the facts that national courts have to do to see if there is or not an abuse in a specific situation. And in this case, what can be pointed out is the fact that we don't know if the mother was pushing her daughter to get married to someone in order to obtain a right of family reunification according to the directive. So, in my opinion, this is a much more important issue that should be solved, if not at the national level in terms of an abuse, at an international level in order to forbid this kind of situations like the child marriage. I will switch now to the third case. The third case is again a case brought before the Court of Justice by a Belgian judge. It concerns a specific case, the interpretation again of the Return Directive, read in conjunction with Articles 1 and 4 and Article 19, paragraph 2 of the Charter. The request was made by a Russian national who developed a rare form of blood cancer. He is in the Netherlands where he is receiving a treatment, and this treatment consists in the administration of cannabis, which is forbidden in Russia. So he cannot obtain the same treatment in Russia, and that's why he applies to receive a residence permit in the Netherlands. Residence permit is refused in this case, so he's illegally staying in the Netherlands and is subject to decision of return in his origin country. The problem in this case is whether the health condition of this person allows him to obtain a residence permit in the Netherlands, or at least to postpone the return decision because he could not receive the treatment that he needs. And in this case, the court says that in the light of the case law, not only of the Court of Justice, but also of the Court of Strasbourg, that the Return Directive and the Charter preclude the return decision from being taken or removal order from being made where there are, in such situation, where there are substantial grounds for believing that the person concerned would be exposed in the third country to which he or she would be removed to a real risk of significant, permanent, and rapid increase in his or her pain. And how does the court interprets these conditions? What is a significant and permanent increase in pain? According to the court, such a pain is established when in the receiving country the treatment cannot be lawfully administered, and when the fact of not giving to this person such a treatment is contrary to human dignity, because could expose the person concerned even to the risk to commit a suicide, because he would lose his psychological capacity. Secondly, concerning the rapid increase in pain, the court says that account must be taken of the fact that that increase may be gradual and that a certain period of time may be necessary for that increase to become significant and permanent, as the court says. Therefore, according to the court, a member state may not lay down a period in absolute terms within which such an increase must be liable to materialize. It can be just a period to take into account, but all the relevant circumstances of the case have to be taken into account by the national authority. And of course, the court states that the decision of the national authority must respect also the principle of proportionality. Here again, on my opinion, we have another important example of the fundamental role played at the national level by national courts in establishing the factual situations and in applying the decision of the Court of Justice. Because once the court decides a case, the court gives an interpretation of EU law, but that interpretation must be applied at the national level in order both to solve a dispute and also to avoid to refer to the Court of Justice requests for preliminary ruling. Okay, in this case, we have a urgent preliminary ruling procedure that has been granted by the Court of Justice. I would just like to point out the fact that in this case, the request was made 2nd of January and the judgment of the court was the 18th of April. So it means 3 months and a half. This is a specific procedure that we have in which we don't usually deliver our judgment in 15, 16 months. We can do it very fast. And consider that half of the period that the court spends to deliver a judgment is for translation, for interpretation at the hearings and all this. So it's very fast way of proceeding. Of course, we cannot grant this proceeding in all the cases, but only in specific circumstances. And African case was one of these. In this case concerns the need provided in national law to submit the application in person to obtain family reunification right with other members of the family. In this case, there was a Syrian national who was recognized as a refugee in Belgium, and so he moved to Belgium. His wife and children, they stayed in Syria, and they want to apply for family reunification. They applied by email and by letter, but the Belgian authorities refused this application because they say, we are sorry, but according to Belgian law, you have to go in person in diplomatic post to make the application. But this lady could not because she was alone with two minor children. She could not move, first of all. And secondly, of course, she was in an area of conflict, so she could not move at all. So here the problem is whether a national law can ask to applicants to be present in person at the real first stage of the application for family reunification. And Also whether this legislation complies with the right to family reunification according to Article 7 of the Charter and Article 24 of the Charter that, which, as I was telling before, needs to take into account the child's best interest. The reasoning of the court in this case is very clear, in my opinion. It says that according to Article 5, Paragraph 1 of the Reunification Directive, it is for the member states to determine the person who is authorized to submit an application for family reunification, and on the other hand, the authorities which are competent to register this application. However, according to the court, there is a margin of appreciation for member states that must be exercised in a correct way and ensuring the objectives of the directive, which are, of course, grant family reunification, and as I was telling before, according to Recital 8 of the directive, to ensure a specific protection for minor refugees. So, in this case, the court said that the fact of requiring the applicants to go in person at the real beginning of the application of the procedure to obtain and to ask the family reunification was contrary to these objectives. And the court said that national authorities and member states, they have to take into account the interest of the children concerned and the interest of promoting family life when they set out the obligations and the conditions according to which an application has to be made. But the court said it is for the competent national authority. So here again, it says it's not up to me to decide, it's the competent national authority which has to make a balance a reasonable balance of all the assessment of the rights that we have to consider in this case, taking particular account of the interest of the children concerned in this case. So the court said that the fact that Belgian law didn't allow any derogation to the rule according to which there was a need of a formal presence at the real beginning of the application did not show the necessary flexibility that member states must show in such situations. And the court points out at paragraph 51 of the judgment that there is a need to allow the use of remote means of communication where people are applying for family reunification and they are actually in areas of conflicts like in Syria or at the Syrian border. So the court states that the national law was, as it was not setting out any derogation to the main rule, was leading impossible in practice for these applicants to make their application, and it constitutes a disproportionate interference with the right to respect for family unit. Why? Because this person could have appeared at the second stage of the procedure because the only objective of the need of the presence of the applicants is to verify his identity. I switch now to the fifth case. I will probably skip this case because you've already talked about this case. It's Commission against Hungary. So I would just like to point out, of course, it was an infringement procedure brought from the Commission against Hungary. And I would just like to highlight the fact that the court said that this national law constitutes a restriction which could not be justified by the objective of public health protection and more specifically the fight against the spread of COVID-19. Why? Because there is a particular test that the courts applies in this case. First, the measure must be appropriate and it must be proportionate. Why the measure was not appropriate? Because if I ask someone who is applying for international protection to go to the border of another member state, and then to be in contact with other people, maybe contracting COVID, then to come back to Hungary to spread it everywhere, this is not appropriate. I mean, to let people travel in order to obtain a travel document with which they can apply for international protection. And second, it was manifestly disproportionate. It was a manifest disproportionate interference with the right of the person seeking international protection to apply as soon as possible when she enters the territory of a member state. I will switch now to the sixth case. These are three connected cases with three different judgments delivered by the court last July. It concerns this time the interpretation of the Directive number 95 of 2018, so the international the directive which has the objective of ensuring international protection. In this case, there was a third country national convicted by final judgment of a particular serious crime. The court has to clarify in which conditions we are facing such a situation. Let's have a look to what Article 14, paragraph 4 provides. Member states may revoke and refuse to renew refugee status where non-EU national who has been convicted by a final judgment of a particularly serious crime constitutes a danger to the community of the member state in which he or she is present. So in this case, we have three third country nationals who challenge before national authorities different decisions to withdraw or refuse them the refugee status because they've been convicted of a crime considered to be particularly serious. So there are three requests for preliminary ruling brought before the Court of Justice in Belgium, in the Netherlands, and in Austria. In this case, the main question brought in the first case is whether, according to this article, the existence of a danger to the community of the member state in which the third country national concerned is present may be regarded as established by the mere fact that the refugee has been convicted by final judgment of a particularly serious crime. In this case, so concerning the question referred by the Council of State of Belgium, the court holds that the existence of a danger to the community of the member state cannot be regarded as established by the mere fact that the person concerned has been convicted by a final judgment of a particular serious crime. There are two conditions to fulfill. First, that the third country national concerned has been convicted by a final judgment of a particularly serious crime, but there is also another condition. The second condition required is that it has been established. So it has to be proved that the third country national constitutes a danger to the community of the member state in which he or she is present. So this condition is not just a consequence of the first one, but must be established at the national level. And here again, the court says that it's for the competent national authority to undertake for each individual case, so here again, a case-by-case approach, if these conditions are established, and to comply again with the principle of proportionality. So here again, the court states that it's up to the national court. So the important role again of the national authorities and the national courts is up again in this case. I will now move to the seventh case. Here again, a request for preliminary ruling brought by French jurisdiction. In a case, OFPRA stays for Office Français de Protection des Réfugiés Apatrides. It's the French Office for the Protection of Refugees and Stateless Persons. In this case, the question brought before the Court of Justice is in which conditions there is a cessation of the protection and of the assistance of the Agency for Palestinian Refugees in the Near East. What is the case? In this case, we have a stateless person of Palestinian origin who arrived in France in 2019. Since birth, this person has suffered for a serious genetic disease that require an assistance that the agency couldn't give him. And so he lodged an application to be granted refugee status or subsidiary protection, but the application was rejected by the French Office for the Protection of Refugee and Stateless Person. But in this case, the National Court for Asylum annulled this decision and granted him refugee status. So an appeal has been brought before the Council of State, and the question is whether Article 12, Paragraph 1 of this directive must be interpreted as meaning that the agency's assistance ceased where that agency is not unable to ensure to the person concerned the access to the healthcare and medical treatment that he needs according to his conditions. And in this case, I will not recall you the content of Article 12, Paragraph 1. I will just recall the fact that when a protection or assistance from an agency is ceased for any reason, the person who received this protection or this assistance shall ipso facto be entitled to the benefits of the directive. So here the question is whether there is no more assistance from the agency, so as the person can obtain a status for refugee according to the directive. And here the reasoning of the court is very clear. According to the court, persons registered with the agency are in principle excluded from refugee status in the European Union. However, where there is no more assistance by the agency, these persons can benefit from the rights coming down from the directive. So the court notes that providing health assistance to Palestinian refugees to meet their basic needs forms part of the missions of the agency. So if the agency cannot give this assistance, the assistance is considered to be ceased. However, according to the case law of the Court of Justice, in order to be able to find that protection or assistance of the agency has ceased, and consequently that the person concerned has been forced to leave the area of operation of the agency, that person's special safety must be at serious risk, and it must be impossible for the agency to guarantee that assistance. So the court states in the end that where the person is exposed to a real risk of imminent death or to a real risk of suffering a serious, rapid, and irreversible decline in his or her state of health, or a significant reduction in life expectancy, in this case, we have to consider that the assistance from the agency has ceased. I move now to the last case I would like to talk about. Here again, in my opinion, another very interesting case brought before the Court of Justice. The Grand Chamber of the Court is actually in charge of this case. The case is pending. We have at the moment the opinion of the Advocate General delivered on the last 4th of May. What is this case about? Again, the right to family reunification, but in this case, in a very specific circumstances. We have one person who applies, a minor refugee, who applies to obtain the status for refugee in Austria. He receives the status for refugees granted to this person, and then their parents and their disabled adult sister, his disabled adult sister, apply for family reunification. In this case, the application is rejected because there is a matter of time limit. I will not stay on this aspect, but I will focus on another important aspect. At least the administration understands that there is an obligation for the member state to grant the right to family reunification of the minor refugees with his parents, according to Article 10, Paragraph 3 of the Family Reunification Directive. But there is a problem with his sister, because his sister has no rights according to this provision. And Article 10, Paragraph 3 of the Family Reunification Directive oblige member states to grant such reunification, so with the minor refugee with his parents. In the directive, you can only find optional provisions, so provisions submitted to the volunteer of the member state concerned to exercise the options laid down in the article to ensure family reunification, to grant family reunification with other members of the family, which is not the case in Austria. So the question here is whether a family reunification right must be granted to the parents in order to allow their minor refugee son to exercise his right to family reunification with his parents, but in a specific situation where this right has to be granted as well to the adult disabled sister, because otherwise the parents cannot join their son. In this case, the opinion of the Advocate General delivered last May pointed out that there are no clear solutions in the directive. I mean, according to the directive, the member state concerned, if it has not exercised the option laid down in the directive, can refuse to grant the family reunification to the adult sister. Because there is an article, Article 4, paragraph 2, that authorized the family reunification in case where the person is depending for her health conditions or her situation from her parents, but it is an optional provision. So Advocate General says, I'm sorry, I cannot do more than that. Family reunification cannot be granted to the sister. The only thing that the administration could do, and I suggest the court to state in this sense, is that there must be a simultaneously exam of both applications. So the member state should examine at the same time the application of the parents to family reunification with their son, and parents should lodge another application according to Article 4, paragraph 2 of the directive for family reunification with their daughter. That should be, these two applications should be examined simultaneously by the member state, but of course only if the member state concerned allows this. Now I would just like to say something and then I conclude. Is that this case is before the Grand Chamber of the Court of Justice, and usually in 65% of the cases the court follows the opinion of the Advocate General. On my opinion, it will be interesting to see if the court will follow in this case the opinion of the Advocate General, or consider that the case has been brought for this reason and only for these questions before the Court of Justice, see if the Grand Chamber would choose a different solution to the case. Thank you for your attention, and I'm here to answer to any question you may have. Thank you.